All right, good afternoon, everybody, and thank you for joining me today for the 11th webinar in the Conn Maciel Carey webinar series. This discussing MSHA record-keeping requirements and document production. So thank you for jumping on this afternoon. My name is Nick Skaila. I am the chair of Conn Maciel Carey's MSHA Workplace Practice Group. In addition to being a certified mine safety professional, I also worked in the industry prior to getting into the legal side of it. My practice works with companies on the production and independent contractor side around the country with MSHA contest and compliance, as well as managing incidents such as fatalities, serious injuries, or special investigations and discrimination investigations under the Mine Act. So thank you for everyone who's joined. Today we will be discussing a myriad of MSHA record-keeping requirements. Obviously, this can't be exhaustive of everything that we may have to require, as that could be different based on our operation, or if we're a contractor, based off of what we're doing and where we're working. However, this will cover hopefully a lot of the main record-keeping standards and regulations, and also give you some information regarding how long we have to maintain those records and how to maintain those records to ensure compliance with MSHA, and also to make sure that we're not overlooking anything that we may be having to do, or maybe doing more than we need to do, and creating a problem for us down the line. So we've broken this down into several different groups, but we'll first talk about workplace inspection reports, or records, and that is going to be beyond just the workplace exam. And then we'll talk about training and Part 50 records, followed by exposure monitoring, noise and respirable dust. And then we'll talk about some basic, or not basic, but maybe some overview of MSHA's ability to request documents either outside the ones listed, or those that may be, documents that are beyond the time frame that we have to keep them. So if there's any questions while we're going through this, please let me know through the chat function, or feel free to contact me afterwards, and we will go ahead and get started. And the first one shouldn't be a surprise for anyone, but our workplace exam record, and we're starting with the real obvious one. But it's important that we realize that as contractors and production operators, we have to document a daily workplace exam at least once per shift. Now, I know there is a lot of talk about the new regulation and the pending final rule that has been kicked around now for about a year. That is now kicked out for an effective date in June 2018. So we have a bit of breathing room on it. We'll see what happens between then and now if we actually get to an effective date. But for the purposes of compliance at this point in time, we need to do our exam once per shift for all working places at our facility. We need to maintain that document for our 12 months from the date of completion. And that document need only have the name of the person who conducts the exam, the date, and the area examined. So when we look at that, we should be realizing that this is much more liberal in the requirements than what that new rule is proposing. In the new rule, we're going to have to do the report or the exam before or as miners enter an area. We'll need to document and describe potentially hazardous conditions that are observed. We will have to supplement the record with the date that those potentially hazardous conditions were corrected. So, there's obviously more obligations coming, and we should be preparing ourselves for the instance that does become a final and effective regulation. But for the time being, we have this as our standing regulation. As we look at that, perhaps keeping 12 months of records at our location is not feasible, in that case, there's MSHA information which says, maybe keep the most recent month, and then you can keep at location, and you can keep subsequent months, or previous months, I should say, at a central location. But you do have to maintain those records for 12 months to comply with MSHA regulations. What you do with them at that point is a company decision, whether you discard them or you continue to maintain them for an additional 6 months, year, or however you see fit. I will say, when creating a workplace exam, many people do more than just that minimum of name, date, and area examined. And if we are going beyond that, if we are creating a document that lists potential hazards or lists defects found, a best practice is we want to list some way, shape, or form that those were addressed. Whether that is, through a corrections column or through a note attached to each one, what we want to avoid is the impression that we were finding a defect and nothing was being done about it. And if we have an area maybe where we're having issue with spillage on a belt, and maybe we are waiting for a new part to come in, and so we consistently have spillage, and each day there is recorded spillage on that workplace exam, and each day it is corrected and cleaned, we're going to want to put on that report, on that exam, that we are addressing it on each date and time, or each day that it's recorded, so that our reports don't just consistently say spillage or cleanup in this area, because then we are going to give MSHA the impression that, or we're going to open up to their observation that perhaps this was a issue that was never corrected, and we don't want that to be the case, because that is going to be a basis for higher negligence, for possible inoperable failures, as we knew of a hazardous condition and did nothing for it. So if we are going above the statutory minimum requirements in terms of what we're including on our workplace exams, we also want to go forward and help ourselves and create that record that we did correct or we did abate anything listed on it. Now again, that's not required, that's just a best practice. And one that I would also encourage for pre-shift examinations if we are maintaining records for those. Now we all know that pre-shift exams must be completed prior to the operation of mobile equipment each shift. We only need to maintain a record if there is a defect found that is not corrected before it is put into operation. So if we do the work or the pre-shift exam and there are no defects found, there is no need to maintain a record. If we are going to find a defect and it may take 2 days to repair, we have to keep that record per MSHA regulations until that 2 days is up, until that defect is repaired. So again, though, many companies are going to keep these records for longer than that. And if that is your company policy, you want to, again, take adequate steps or take steps to protect yourself, such as what we just discussed. If a defect is listed, if a repair is listed, make sure we're recording that this was either investigated by maintenance personnel and determined to be a non-hazard or a non-defect, or that it was repaired or corrected. And we want to do that so that it is not, again, creating a history or creating a pattern of a similar or consistent defect listed on a piece of equipment. We'll also want to take into consideration when doing this the equipment that is being inspected, and are our personnel properly trained on how to conduct those inspections. For example, and it might seem trivial when we're discussing it at this point, but if a piece of equipment has air-powered brakes or horns or something of that nature, we want our personnel to know that they have to let that air pressure build before they can adequately test those features. And so we're not getting a list or a pattern of pre-shift exams that continue to say there's a defect that may not be there when someone goes to look at it later on. The question often arises is, does a new operator, if they take control of a piece of mobile equipment during the shift, should they create a new pre-shift exam or conduct a new pre-shift exam? now the MSHA regulation is somewhat vague because it says that you must complete a pre-shift exam for each piece of mobile equipment before it's placed in on the shift. And so the shift is very clear. But if we're switching operations mid-shift or switching personnel on a piece of equipment mid-shift, while it's not required, I would recommend that the next operator either complete their own work or pre-shift exam or review the workplace exam with the previous operator, just to ensure that there is continuity between anything that may have been identified or not in that morning or at the beginning of shift before another person steps in to operate it. But if you don't find any defect, this record is not even required to be maintained. Another workplace safety regulation or record regulation is continuity and resistance testing. And oftentimes we aren't the ones doing these tests. We're having them done by contractors. We're aware that we have to do it at least annually. But additionally, we also have to maintain this record after installation, repair, modification, or for a portable plant if we move the plant to a different location. So there's a number of reasons why these these continuity and resistance testing would be occurring much more frequently than annually. And they don't have to be for the entire facility. If we've repaired a single piece of equipment or a single motor, we can run it on that specific item. But we have to maintain those records, and we have to have a history of those most recent records, and really you want to keep them for the last year, even if we have done subsequent tests for repair, installation, or modification. So, if we have done them annually, but we had to do a repair, I would suggest you keep the most recent annual test as well as the repair modification test. And that's to give MSHA a good basis that you have done these tests, you do have a pattern of doing it on an annual basis at least, and you're maintaining those records. Now, one part about this is, as we talked about, we're likely having a electrician or a contractor perform this. And if they are an outside contractor, we want to make sure they're performing that test properly. And most importantly, we want to make sure that they're creating a sufficient record for us. We don't want to go through it and then have a defect in our records discovered. And obviously we want to trust that the contractor will do it, but given the strict liability of the Mine Act, that is not always that is not a defense to if a record is defective or if the test was not done within that year. So we want to look at these records, obviously, when they're completed. We want to make sure that the record is adequate, and if not, we're going to need to address that with the contractor to make sure that they are done properly. Another workplace inspection report, and we're going to call it this because it is for something that is typically maintained in a fixed location, is your fire extinguishers. And the regulation, which is 5657 for metal non-metal 4201, it really includes two distinct requirements in terms of record keeping, and these are often satisfied simply with those punch tags that are hung on the end of them, but nonetheless need to be completed independently or completed on these two different time frames we need to keep in mind. So, the monthly one obviously is going to be a visual inspection, and when we're looking at this, we should be looking to determine if the fire extinguisher still has a full charge on it. Is it still going to be able to operate? Has it been discharged in the time since the last inspection and not replaced? Or is there any obvious defect that we see on it that will make it inoperable in the event of a fire? And the next part of it is that every 12 months, or once a year, we need to conduct an evaluation of all the mechanical parts on it. and we want to know the amount and the condition of the extinguishing agent. We want to look at how the parts are wearing, if there is any wear on them, or if there is any environmental degradation of the fire extinguisher. And that's going to be all the elements such as the nose, the hose, the nozzle, and the vessel to determine if it will operate effectively. So while we're doing more of a visual and cursory review on a monthly basis, we also need to maintain a record, which again can be on the same form as the monthly, but every 12 months that we have done a visual inspection of the mechanical parts to make sure that everything is in good working order and still appears to be able to work in its proper function when needed. So, related to this, and not a record we need to be maintaining, but we do have to establish procedures and coordinate in advance with our local firefighting organizations or any on-site. We also are going to have to establish evacuation and procedures. So we want to make sure that this is something that we do, and it's not going to be one of those records that is checked specifically with the fire extinguishers, but it's nonetheless one that we need to have a procedure in place. We need to have those training in place so that our people know what to do in the event of a fire and where to go and when and who to call. So these are some elements that we don't want to forget about. Fire extinguishers can be obviously in many different locations around the facility. They can be on mobile equipment. They can be in fixed locations in an office or a shop or a scale house. But wherever they are, we do have to conduct both of these inspections and maintain a record of them, and the monthly one being obviously the more time-consuming in terms of its frequency. First aid is also another one which we must maintain a training record of, and this is actually going to be part of those training records that we maintain for production in our training plan. But also, each shift we must have someone with current first aid training, and we must maintain a record of that person on site so that they can provide that first aid if needed. It's going to be typical training in terms of what is expected, and that's going to be patient assessment, CPR, treatment for shock or wounds, burns, and sprains. These are minimums in what's going to happen. Now, many operations have their larger operations have their own first responder squad, and we should also have established procedures similar to the fire, procedures for our mine to contact first responders when needed. But nonetheless, we need to have someone on site. We need to have a record of at least that one person that is able to perform these functions, these minimum first aid functions, when MSHA comes to inspect. This can be part of your new miner training if you want to provide it to everyone. It must be made available first aid training to any miner who is interested. But in terms of our record-keeping requirements, we need to provide a list of that person for each shift, of at least one person per shift who is able to satisfy this. So those are obviously some of the less surprising and less demanding records that we are aware of. Training records is obviously a big part of our record-keeping requirement. Whether we're a Part 46 or a Part 48 training plan, we are going to have requirements for maintaining our plan, records, different types of training, and we are going to have to be able to produce those to MSHA when they come on site for inspection. And additionally, if we're a contractor or we're a production operator, unless we are not going to qualify as miners and therefore not subject to the Part 46 training plans as an independent contractor, we are going to have this. In terms of a copy of the training plan, the requirement for MSHA is that we must be able to provide a copy of that training plan for their inspection and review by the day following that request. Now, typically these are maintained on site, but in the event that they are not, we must be able to get them a copy by the next day. Training documents, on the other hand, must be kept, though, in a place where they can be produced to the inspector on the same day as the request. And typically that means on site. And also, we want to maintain that we have copies. And if we are providing copies or records to MSHA for review, we want to be able to provide them, not our originals, especially in the event of an incident or an injury investigation where MSHA will be taking documents with them, or if there's citations issued just in the course of a regular inspection. We don't want that document to be removed from site without us having a record of what it was. So in that case, we want to have our originals, but we also want to maintain copies in order for us to provide them to MSHA in order for them to review. And also, if MSHA is ever going to remove documents from our site, they should not be removing originals. They should be requesting copies or making copies. But in the event that they do, we need to police that. And we need to provide MSHA with copies of any document that they take. And we need to also, and this is a recommendation, but also maintain a list of anything that MSHA takes during the course of an inspection, incident, or investigation. We want to make sure we know at a later date what exactly they have in their records so that we can be reviewing the same material at the same time. In terms of submitting these documents to MSHA for review without an inspection happening, the Part 46 plans, obviously, we don't need to have those approved by MSHA, and we only need to have a competent person providing that training. If we are a Part 48 operation, though, our training plan needs to be submitted to our district manager and approved. And additionally, we also want to or have to have an approved trainer administering that training plan and providing that training in it. So those are, differences between the two, but many of the internal documents, such as, new miner training and such, there's going to be overlap there. If we are a production operator and we're having contractors come on site and we know that they're going to satisfy the requirements of a miner and therefore need miner training, a good question to ask ourselves is, are we requesting copies of their training plans and training records so that we can have a copy on site if needed for our own purposes? Or are we requesting a copy during pre-qualification or bidding and then returning it to them? Have we done any due diligence to ensure that our contractor that we're hiring is actually satisfying those requirements? There is a long line of cases out there that say that MSHA can issue citations to both a production operator and an independent contractor for deficiencies or violations of the contractor. And part of that is included in the training, especially if an independent contractor is found to be in a dangerous situation and found to have inadequate or not to have training required. The contractor and the production operator can be cited for those conditions. So we want to make sure that we are auditing not only existing contractors, but new contractors to ensure that the people they're sending out on site are having up-to-date training, as well as that their training plans exist and are sufficient, because we don't want to be put in a position that we are having these people come on site without understanding what their training is or if they actually have training. In terms of monitoring or maintaining records, obviously these are going to be the big hitters of the training plans, other than the plan itself. But it's either the new miner or the newly hired experienced miner training, annual refresher, first aid is going to be part of this, and these are all those records that need to be provided the same day the inspector asks for them, or task training and site-specific hazard awareness. So, an important part we've mentioned several times that, in order to, or when you have an independent contractor come on your site, we should be ensuring that if they are a miner, they receive or have a training plan and have that miner training. With regard to site-specific hazard awareness, this applies to everyone that comes on site. We need to make sure that everyone coming on site is going to be receiving their site-specific. And, if we are, it outlines it very clearly, especially in Part 46, 46.11 is the regulation, what needs to be covered in site-specific. And we need to make sure that that is being covered either by in-person training, reviewing of written materials, or it can even be accomplished through signage if that signage is readily visible and covers all elements in it. But this is going to apply to customer truck drivers, delivery drivers, office workers, anything of that sort. There really is no workaround for site-specific unless we're going to be accompanying the person by an experienced miner at all times. But for day-to-day operations, we really need to make sure that everyone's getting this site-specific. In terms of task training, we want to avoid situations where we are providing training and then not recording it, because a big element of the task training, obviously, is the task training document. With MSHA, if there is no document, it's very hard to prove that that training occurred without any record of that occurring. So, as part of task training, we can do field work and observation. That is permitted. But what we need to avoid in that situation is failing to document it, because then we don't have an agenda. We don't have a date and time that it was completed. We need to make sure that we reduce all that training to writing. As we know, task training can be a bit of a rabbit hole with MSHA, and especially in the event of an incident or a serious injury or fatality, when MSHA can come out and no matter what training has been received, they can determine if it was not provided that it's a violation, or there was no record as it wasn't provided, or if it was inadequate. And even if MSHA acknowledges that task training was provided, we can still receive a violation for not having a record of it. So we need to maintain those records. We need to reduce training to writing soon thereafter. When we do annual refresher, we do new miner, it's typically a controlled situation where we are going to have forums, we're going to have everyone together. Task training might not always be administered under those same circumstances, but nonetheless, we need to be diligent in maintaining those records and reducing that training to records. So that's an important element of the task training that I see far too many people maybe skipping over, because they had someone working with an experienced miner who was showing them how to do a specific task and did so for a number of days or a day or a number of hours in that day. However, which would be more than sufficient to cover task training. However, we fail to record it. And then when MSHA comes out and they see an individual performing a task or operating a piece of equipment and want to see the task training for that, we can't provide it. So that is a situation, obviously, that we want to avoid. Not only because even if MSHA acknowledges our training, we can get a citation for failure to document or failure to provide a record, but also because MSHA is typically of the mind that if there is no document to memorialize the training, it did not occur. Another element of task training is going to be the hazard communication or HAZCOM program. And this has its own section in the Mine Act. It's Section 47 or Part 47 of the Act. And it is specifically addressing chemicals or hazardous chemicals at the site. And, our program, it needs to not only be something that we reduce to writing and maintain in order for MSHA to inspect along with the training records on it. But we need to, there is sufficient requirements within that of items that we need to cover. Now on the slide, the orange italicized part, that is actually from the regulation. And, in it, we need to identify chemicals at the mine. We need to put analysis or determination of which are hazardous. We obviously need to create this HAZCOM program to protect against it, and we need to inform each miner who can be exposed, and that's a very broad term because unless we are isolating someone to a very narrow spot that they cannot or do not leave under any circumstance, they most likely can be exposed to most elements on our mine site. We also have to be able to provide information to other operators on site who can be exposed to any chemical. So, this includes not only a master copy, but, MSHA would recommend, and I think this is also a good recommendation based on our discussion about training records, that you maintain a master copy and a field copy. Because this is a document that needs to be on site. It needs to be made available to miners as requested, as well as MSHA as requested. So we want to have a backup copy so that if anything happens to the on-site copy, it can quickly be recreated. We don't want to have to go through this whole process and recreate our collection of MSDS forms or recreate our entire program if it's the case that it gets misplaced or destroyed. So included in this is going to be a list of the hazardous chemicals to be found on site, material safety data sheets or MSDS forms. MSHA has not moved over to the globally harmonized system, although they are accepting those. They are not requiring it, and as well as the HAZCOM training records. So, that gives a brief overview of what a HAZCOM program includes. And some more specifics are, we need to put in a number of different elements in our training, such as hazard determinations, labeling, and other forms of warning. And that can be warning, whether it's warning labels or having adequate written descriptions on our containers. We don't want to have a situation where a 5-gallon bucket is holding some kind of substance that is not labeled. And you can see the citations, which are frustrating, but nonetheless are issued for substances such as those kept in, small containers by mechanics, and they might be motor oil, or they might be a bit of supplemental steering fluid or something like that. But if those are not labeled, that can be a violation of the HAZCOM program because we're not properly labeling. Another important element is we have to be able to share that information to other on-site operators who people can be affected. And that means providing them with a copy of any hazardous substances that they might run into or that they could be affected by. Also, if we are a facility that creates a hazardous substance or one that could be hazardous to individuals, we have to provide, upon request, our chemical label and a copy of the information and the MSDS. So, not only is this applied to things that we bring on site, but it could apply also if there is any, byproduct or intentional product of our operations that, could be classified as a hazardous chemical and included, therefore, in the training for HAZCOM. Another significant element of the record keeping, obviously, is going to be the Part 50 records. And if you're familiar with Part 50, it's going to be our injury and illness reporting documentation. And, that includes not only 7001s, but it also includes our quarterly reports and our operations, as well as investigation reports. These are records that either have been submitted to MSHA, will be submitted to MSHA, or should have been submitted to MSHA. Frequently we see that failing to report on a 7001 can be the basis of hazard complaints. It seems to be an easy way for those complaints to be made if a miner feels that something that should be reported wasn't reported. So we want to be clear in our analysis. We want to make sure we review any type of incident, illness, or occupational injury that takes place on our site for submission to MSHA. We can also, if we are found to have a violation or if we incur a fatality at our site, we will get audited under a Part 50 audit. And that means that MSHA will come through and go through all of our Part 50 records, whether it's quarterly reports or injury reports, as well as any other documentation that is created to supplement that. that is maintained, and they will look for all those, and we can, unfortunately, sometimes these Part 50 audits can result in a significant amount of citations, and that's because the record-keeping requirements and the maintenance requirements for Part 50 are pretty long. If we're looking at, the quarterly or the injury reports, we have to maintain at the office closest to the mine for 5 years, maintain those records after submission. And we also have to maintain, if we have any incidents or accidents, a copy of our investigation report, our internal investigation report that is created for submission to MSHA for also 5 years. So that's a long time to maintain a record when we are looking at workplace exams as our most recent or our longest record to date, which was just 12 months. In terms of the Part 50, what is going to be expected? Well, if we're having a serious or an injury or an accident or an occupational injury at the mine, we must have a record created that is under Section 50.11. Again, this must be kept for 5 years, and what it is it's essentially reducing the 7001 form to another form, because it requires, the date and hour of the occurrence, the date of the investigation began, name of those participating in the investigation, description of site, explanation of the accident or injury, name and occupation and experience of miner involved. If it's applicable, they want a sketch included of the occurrence, as well as steps taken to prevent similar occurrences. And then they also want you to identify on this record for 50.11 anything submitted under the standard for reporting injuries in 7001. So, it is very much a similar document, and if, you want to maintain a record for 50.11, that you want to maintain a detailed internal root cause analysis investigation, you can do so separately, but just make sure that you are maintaining this 50.11 file, because while you don't have to submit it to MSHA, it can be requested at a later date and time for review. If we are dealing with an occupational injury at a mine with less or fewer than 20 miners, then they can use a 7001 as their form for 50.11, but that does not include accidents, and we're talking about accidents in terms of, that dirty dozen, as MSHA calls it, that are immediately reportable. That is their definition of an accident, and but we're just looking for an occupational injury in this case. But for the most part, this record has to be created, has to be maintained for 5 years, and it is specific in what MSHA is looking for. For the reporting of accidents and injuries, this is under the next part of this standard in Part 50, 50.2, or 50.20, and this is following reportable injuries or illnesses in the mines. And this is a 7001 form that we are all, I'm sure, familiar with and have all dealt with at some place in time. So we have 10 working days to file this. It can either be filed electronically through MSHA's website or by fax or by mail. The electronic format is pretty simple, and you don't have to follow the procedures of submitting multiple copies to multiple entities that you do if you file by mail. Again, this must be maintained for 5 years. The question when filing this is the injury reportable or not? And, in order to make that determination, we have to, do a review of, often is this going to be considered medical treatment or first aid if no time is missed. If there is time missed, we are likely going to be looked at what is considered an occupational injury, and therefore we don't have the, ability not to report it. If it classifies as an occupational injury, it is going to be reportable. And so we need to do a bit of analysis when we look at this, and, very often people want to get this in immediately. And, I encourage people or companies to look internally at this and see if it is actually reportable, or collect a bit of information before you file it so you're not filing an incomplete or maybe an inaccurate record, or one that does not have to be filed. So we want to do this analysis and see if this is going to qualify for a Part 50 7001 form. If we are looking at an occupational injury, that is, MSHA defines it as an injury to a miner which occurs at a mine for which medical treatment is administered, or which results in death or loss of consciousness for any amount of time, inability to perform all job duties on any day after an injury. So if we get an injury today and we cannot perform all of our job duties tomorrow, we have to submit a 7001 because that is now a occupational injury, or temporary assignment to other duties, or transfer to another job. So, the definition, people oftentimes gets bogged down in whether or not someone is being administered or receiving medical treatment or first aid, and that is an important element of it, and we must continue to look at that and try to evaluate it, but that's not always the only thing we have to look at. And this definition of an occupational injury, which immediately makes something reportable to MSHA for the purposes of this section, it encompasses a lot of different events. It encompasses quite a few different events. So we want to make sure that when we are looking at our first aid treatment or our medical treatment, if someone was evaluated or diagnosed or provided some form of treatment, we also want to look at that definition of occupational injury and see, is it going to fit into this category? Because then, regardless of their ability to continue or the lack of treatment that they receive, it may still be reportable. We also want to be sure to monitor this if we're a production operator regarding injuries or occupational injuries and illness to contractors, because this is going to be something that as a production operator we have the final responsibility to file. So we need to ensure that if we are having contractors on site and they are going to file this, make sure we follow up with them. If you can get a copy of the report for your own records, I would recommend you doing so to ensure that you have not filed it on behalf of the company, but you have done this. If your company policy as a production operator is to submit any incident that comes on site, even if a contractor is going to submit it as well, my understanding, having spoke to the people at the MSHA office out in Denver that monitor and maintain these records for the agency, is that if they get two of the same incident reports, the 7001s, and one is from a production operator but listed as applying to a contractor, and one is from a contractor, they will discard the mine operator copy and file it as an injury to the contractor's record. But nonetheless, if we come out and get an audit and there are incidents that occurred on site that should have been reported, but were not because a contractor didn't do it, we can still, as a production operator, receive citations for that, because ultimately it comes down on us to provide those records or report those incidences and maintain those records. So that's why we're going to want to get a copy of what was provided. There's also a document called the MSHA Yellow Jacket, and this is a very helpful document if it's available online, or if you can't find it online or just want to do it an easier way, email me and I can get you a copy. But this is a document that really goes through the Part 50.20, the injury and illness reporting requirements, and it really breaks it down into examples and different types of instances and how they are going to be evaluated if they are medical treatment or first aid or vice versa. With the quarterly reports, most of us are pretty familiar with these, and so we won't spend too much time on them, but just ensure that they are being submitted to MSHA by the 15th of each month after the quarter. So January 15th, April 15th, July 15th, October 15th, these are the dates and times that we need to have these submitted by. And if we don't, if they are late, that can be a citation. Now, it's obviously going to be a paperwork citation. It's going to be likely non-SNS, but especially if we get a pattern of this or have a collection of them that are not being filed in a timely manner, they can get higher up in negligence. But really, they're just a citation we shouldn't have to worry about, given that it is paperwork. It's just submission and filing, and we have until the 15th of each month after the quarter to provide that information. The next type of requirement is going to be exposure monitoring records, or the programs that control them. So when we're looking at it from a respiratory protection program, we're looking at, this is set out in 5657.5005. And this is going to be a required document if MSHA finds an overexposure to an airborne contaminant. But even if they have not, and we are requiring individuals to wear respirators, we should have a respiratory protection program in place. And that protection program should cover all the elements, of a selecting or using respiratory protection PPE. That will include determining whether or not someone is medically fit to wear a PPE, a respiratory protection PPE or a respirator, as well as fit testing. We also want to make sure that there is training on proper maintenance and cleaning and storage, because those are areas where we can see, especially if they're not used frequently, PPE degrades. And then when MSHA comes on site, it's found to be non-compliant because it is in such a state. So if we are not looking at these, because we haven't been cited yet, but we require individuals to wear respiratory protection on site, we need to be considering creating a respiratory protection program. MSHA is, obviously going to conduct their health sampling each year, and this is an area that we are seeing a bit more attention on. Also, part of the exposure monitoring records is going to be noise monitoring or hearing conservation programs. And the program itself is going to be required if we have exposure above the action level at the mine, and that is going to be 85 decibels over an 8-hour time-weighted average. If, this is also going to be part of MSHA's health sampling, given what we do or what you all do as occupation, this is likely going to be something that we have in effect or should have ready for rollout in the event that we get an overexposure or someone exceeds that action level. So it's going to have to include portions on audiometric testing, training, record keeping, monitoring, as well as use of hearing protectors, and that can be inner ear or muffs or anything of that nature. It also is going to have to outline different elements in terms of when double protection is needed for hearing. It's going to have to outline the different elements of how you will administer this program to ensure that individuals are receiving their needed hearing protection. Now, in terms of providing this information to MSHA, we need to be able to provide all the records under this part, and we need to be able to provide them to MSHA upon request. We typically will have some time in order to provide it if it's not all maintained on the site. There is the ability of some miners to opt out of the medical text or the audiometric testing if they do not want to participate, but we will need to get that in writing from them. Finally, some miscellaneous records is the legal identity form. So we probably think that this is just a pretty staple document that has been submitted to MSHA, but there is a requirement to update it within 30 days of any change to the operation. And mainly this is going to be the change to the person in charge of the day-to-day operations, or the person who has overall responsibility over the site, if that is not the same person who's in charge of day-to-day operations. You have 30 days from the date of the change to submit this to MSHA, and we want to keep track of those changes. I just had a company I was working with get a citation over this standard because they were issued a citation because MSHA or the inspector did not believe that a timely change of personnel was submitted. Well, when we were able to provide them a very simple document that was the HR from the HR department stating when a person took over a specific position, the citation was immediately vacated. So keep note of when these changes occur. We're also going to want to maintain an independent contractor register, and this must be on site. When MSHA comes on site, it's going to have to be, the contractor's name, their contact information, along with their MSHA ID if that exists. We're going to need to be able to provide this to MSHA so that they can properly conduct their inspections. So, some questions happen is what happens if MSHA requests documents that aren't required to be maintained? This is a situation where we have to tread carefully. We can't just tell MSHA to, buzz off on that. We have to carefully consider our options because while they don't have subpoena power for documents per se, they do have a great deal of latitude in what they can request of us. And we need to, take time and determine, is this more than would be, reasonably required to enable them to perform their function, or are they requesting something well outside those bounds? If we are in a situation where MSHA is requiring documents that aren't required to be maintained, or requesting those documents, we need to consider our options and also consider discussing it with them whether or not that is something that's applicable. Because, there's the question of, what happens if we have privileged materials? Well, if those are privileged, they are going to be protected under that right. And I say that in terms of, the possibility of having a privileged audit report on site. But, if they are just simply documents that maybe we created in the normal course of business, we are going to have to, judge carefully whether the risks and rewards of not providing them. And I'm not saying that in every case you should just turn over anything MSHA wants. I'm not saying that by any means. But we want to tread carefully because we don't want to get into the situation where we are going to be threatened with or receive an impeding the investigation order, because that is never a good thing. And, they do have very, very broad powers under their request, their Section 103H, through which they can request those documents, and that's been pretty well established in the case trial. In terms of records that we're required to maintain for a specific amount of time, but we retain them longer. Questions with what happens if MSHA requires that? Well, we need to look at that from the company perspective of what is our internal document retention policies, and if we don't have them, we're going to want to establish those if they are something beyond what MSHA requires. And, namely, I say, are you going to keep workplace exams for 4 years? I'm not sure why or what reason you would have to do that. But, at the same time, if MSHA is conducting an inspection and they want to see a workplace exam from 2 years ago and we have it, there's a question of how is that applicable to the current status today. But, say they got a hazard report that this condition existed for an extended period of time, so-and-so ago. That's going to be something that's hard for us to block access to. So, I encourage you to review their record-keeping requirements and as well take that and review our internal ones. So we don't need to keep 10 years worth of Preshift exams when MSHA doesn't require to keep them at all once the defect is repaired, if any is found. And MSHA does have the ability to issue citations for, either specific items or trends, or they can use it as a basis of increasing negligence on currently issued citations. So we want to avoid that. In terms of some takeaways from this, and I know I'm butting up against the end, so I apologize. As I just said, we want to be cognizant of both the record-keeping requirements by the agency as well as our own. We want to make sure that, neither one is in conflict to the other. And also recommend that unless we have a specific purpose for keeping documents beyond the MSHA requirement, we try to stick to those. And if we are maintaining documents longer than those requirements, we have a specific purpose or a specific retention policy for them, not just an open-ended keep them forever. We want to have our records stored in assigned locations at the site so that we can easily get to them and then we can easily provide them without having to dig through a bunch of other records that are not pertinent to the MSHA investigation that we want to keep distinguished. We want to also keep a record or a log of anything that is provided to MSHA, whether that is copies, so that we know where they're at. If we are updating records, we want to make sure that all copies and the originals are updated. Or if new sections are being added to anything, we want to make sure that it is across the board. Another good option for this is obviously reviewing your document policy or your documents on a regular basis to see if you're having or if your records are sufficient, and that can be done internally, whether from site to site or by your internal safety and health team or legal team. It can be done by working with someone like me or a third-party consultant, who does this kind of thing. Or MSHA has the educational field services, and these people are out there. They are limited in what they can do because there's so few of them at this point. And they typically don't provide too much resources to large corporations or companies they feel have the ability to go elsewhere for the assistance. But record keeping is one thing that I found that they are typically able to help with and able to help with readily. So if you want to have them review these EFS personnel don't have the ability to write citations. I know there's always the stigma or the thought that they could go back and report it to the enforcement personnel, and we obviously have that concern, but if we don't agree with a recommendation provided by them, we need to address it in some way, whether by determining another way to be in compliance or by acknowledging that there is a difference of opinion in the application of that recommendation. But nonetheless, the EFS and small mines people, they are pretty well versed in what the inspectors are looking for in terms of your record keeping, and it could be a way to check and see where you're at prior to an audit or an inspection by MSHA on the record side. That is not a bar from getting a citation later on, unfortunately, but nonetheless, it can be a useful tool, especially if we're a smaller operation or one that is new to MSHA, in having someone make sure that our records are up to date or at least on the right track. So with that, I appreciate everyone stopping by. Please join me next month for the last webinar in 2017. And if there's any questions, please let me know. And if you don't want to do so on the chat function, please feel free to contact me at any time. I'd be happy to be a resource. Thank you.